My first chance to rise on this matter of supply today. I had hoped to put some of these questions to my Conservative colleagues. There must be more answers in this question, and to my honourable friend Parliamentary Secretary, I want to suggest to all of us here in this place that getting to the bottom of this is crucial, but we mustn't jump to conclusions. I'm keeping an open mind as to who was calling the shots. Who was it who asked the Clerk of the Privy Council to phone our former Attorney General at home and for an hour and a half threaten her, contents of a conversation he claimed he couldn't remember because he wasn't wearing a wire? I want to suggest some other names to this place, names that haven't been mentioned. Gwyn Morgan was chair of the board of SNC-Lavalin through many periods in which they are now investigated for corporate crime and bribery. He was also chair of the Board of Governance. Questions at the time were raised about his role and what should have been known in good governance of SNC-Lavalin about the nearly $50 million which somehow got past their notice as a corporation. Easy to lose $50 million? I doubt it. They have the same auditor they had in the beginning. No changes. I mentioned Gwyn Morgan because he was a major contributor to the BC Liberal Party and Christy Clark. And Ben Chin, the first name mentioned in the 11 people who harassed and pressured our former Attorney General, was, of course, formerly at the right hand of Christy Clark. In other words, there are plausible trails of those who put pressure. There was the former Harper administration full engagement in promoting Arthur Porter to a place of honor, even though he was a co-conspirator with SNC-Lavalin. Thank you, Madam Speaker.
The Honourable Parliamentary Secretary of the Minister of Justice.
So I thank the member from Sandwich Gulf Islands for her contributions today and her contributions to this chamber generally. In terms of what she's raised about SNC and good governance issues, I think it's important that the record reflect that concerns about good governance of any corporate institution in this country are pivotal. And I think some of what's been lost in some of the discussions over the past several weeks on this matter have failed to address or note that even in the context of pursuing remediation agreements, corporate governance and good governance is central. In the legislation at 715.34, it talks about in subsection 1 that any remediation agreement that might be pursued requires an agreed statement of facts, an admission of responsibility, a forfeiture of any benefits, restitution for victims, and a payment of a penalty. That's the kind of good governance that all Canadians seek, that all parliamentarians seek in this context. With respect to the specific names, I have no knowledge of those individuals or their roles that may have been played in this context.
Closing comments. The honourable member for Mount Royal.
Thank you, Madam Speaker, and I want to thank my honourable colleague for his speech. I wanted to clarify something that seems to be a subject of some debate. Before our committee, all of the relevant witnesses as to the facts spoke under exactly the same order in council. All of them had the same waiver of solicitor-client privilege, and all of them had the same waiver of cabinet confidence. No witness that came before the committee spoke to the period following the date that the honourable member for Vancouver-Granville became the Minister of Veterans Affairs. And so our committee study, Madam Speaker, was on the subject of the interactions between the Office of the Attorney General and other government officials. And the issue that we were looking at was whether or not the former Attorney General was pressured in her role as Attorney General in order to reach a remediation agreement with SNC-Lavalin. So my question, Madam Speaker, to my honourable colleague is it possible that after she became Veterans Affairs Minister, that someone could be pressured to enter into a remediation agreement with SNC-Lavalin?
The honourable member for Parliamentary Secretary, sorry.
So the answer to that, and it's an erudite, tight question, the answer to that is no. It is not possible pursuant to the law. The only one who has the power to enter into a litigation decision is the Attorney General of Canada at the time. They can either take control of a particular piece of litigation or issue a litigation directive pursuant to the governing legislation. That's the Attorney General only. I think what's important to outline as well in response to a further, and I thank the member for his stewardship of the Justice Committee and for the important decision they've just taken to pursue a study of online hate. But in further clarification to a member that was question posed by the member from Victoria, the actual issue of the medical leave was not established as permanent, so the question he put to me with respect to Section 44 of the Conflict of Interest Act is actually hypothetical.
Questions and comments? The honourable member for Leeds, Grenville, Thousand Islands, Rideau Lakes.
Thank you, Madam Speaker. So the parliamentary secretary talked about the work that the committee had done, including the witnesses who had appeared before the committee. And while some of the witnesses that members of the opposition had requested appear did appear, others have not been allowed to appear. And we have requested that the former Attorney General return, and that was not the case. Now, the parliamentary secretary referenced former Judge Turpel-Lafont appearing before the committee, and he also referenced the Shawcross Doctrine. And so I just want to pull a quote from former Judge Turpel-Lafont, and that's that I think it's fairly flimsy foundation as lawful authority in respect of the Shawcross Doctrine. So my question through you to the parliamentary secretary is, knowing that the grounds by which the former Attorney General was approached have been identified as fairly flimsy, and seeing with the Mark Norman case that this government is not afraid to prosecute people for stepping outside of cabinet confidence, does he think that the Order in Council is sufficient, and why won't he let the former Attorney General speak?
The honourable parliamentary secretary, the Minister of Justice and Attorney General.
So I think taking the unprecedented step of waiving solicitor-client privilege was important, and it demonstrates respect for transparency and openness in this matter that has been rightfully raised by many parties in this House in terms of what exactly transpired. I think the discussion about the Shawcross Doctrine is equally important. And my response to the member opposite, and again I congratulate him on his election and also on participating in the Justice Committee to date, is that the important thing is that the Justice Committee has shone the light on a very pressing issue, and that's an issue that's bearing further study as to whether the role of Attorney General and Minister of Justice should remain fused, as it has for 152 years now since Confederation, or whether it should be separated. That's exactly what the Special Advisor is looking at, because it bears further scrutiny.
Time for a brief question. The honourable member for Sandwich Gulf Islands.
Rare chance for a follow-up. To my honourable friend, the parliamentary secretary, unfamiliar with Gwyn Morgan, he was the person that you may recall Stephen Harper attempted to appoint as chair of the Public Appointments Commission process. The interviews about that process ended the process of having parliamentary committees interview prospective candidates, because when Morgan underwent a rough ride, his heavy support for the Conservative Party being raised as a reason that perhaps he shouldn't chair the Public Accounts Commission. I think it's entirely possible that the reasons that there is pressure not to have this go to open court is to protect the reputations of business leaders such as Mr. Morgan.
A brief answer from the parliamentary secretary.
Again, what I would say to the member opposite, and I have a tremendous amount of respect for the member for Sandwich Gulf Islands, is that I have no knowledge of that individual. That name has not surfaced thus far in any of the proceedings that I've been following. And what I can say is that the issue of corporate governance is a critical one. It's one that we're looking at very closely. And in terms of the powers of a court, the Ethics Commissioner, pursuant to the powers that are entrenched in statute, actually has the same powers of a court, as I've articulated, with respect to summoning individuals, putting them under oath, and compelling documents and the production of documents.
Resuming debate.